the problem with it is if we reject this notion of the progressive precedent, that many judges and lawyers are still going to hold it, and we're probably not going to convince them. So how do we fight back? Well, the Sixth and Seventh Amendment guarantees you a right to a trial by jury. Do not surrender it no matter what. Be firm on it. Juries have the ability to nullify judges' rulings. It's worth warning you. Unfortunately, juries find guilty 95% of the time. Now, I don't know what percentage of these that somebody's actually guilty of a crime. I suspect that to a certain extent that the request for a jury trial is just a last-ditch effort to find a way of getting off. And so it might be that that 95% is stacked a little bit. But nonetheless, it's a stat that's worth considering. 95% of the time somebody's found guilty. So this is a little bit of a gamble. But Thomas Jefferson said, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution." So if you think that this is a radical notion, well, speaking of Thomas Jefferson, this is actually what he proposed, is if the judge believes something, the lawyer believes something, but you hold a view in opposition to that, and your view is the Constitution, and their view is in opposition to the Constitution, then Thomas Jefferson says, demand a jury trial. This is the only way that we have in our Constitution of basically holding their feet to the fire, of forcing them to abide by the Constitution. Inform juries about nullification in the Constitution. Don't take no for an answer. So tell this to the juries. Here's the problem. I would suspect that some judges will sit there and say, well, you can't tell them that. Well, look, there's a bigger stake here. There's a bigger picture. I say tell them anyway. I would rather force a mistrial than just let them win. Even a contempt of court charge could potentially be fought at a later date, citing that the judge was denying you your constitutional protections and and by basically saying that you can't tell the jury, read the Constitution. This is what it says. There should be nothing wrong with that. Sixth Amendment also grants a right to be confronted by witnesses. Don't let them remain anonymous. And that's an interesting thing. I've been learning as I've been studying this that there are a lot of cases where a complaint is anonymous, and in some of these cases there is not even an actual complaint. That they use the notion of anonymous tip, anonymous complaint as a way of just basically bringing forth, the local government are bringing forth what they want to push anyway. Mr. Anonymous. But an anonymous complaint, once it goes to a court of law, is unconstitutional. Smoke them out. Determine whether or not there is, one, a real complainer. If there's not, then at least you've exposed the local legislature, the local authorities, as being the source of this ruling. If there is an actual complaint, some of them will drop their charges when they realize they're about to actually be confronted. Also point out, too, hecklers are not allowed a veto, especially imaginary hecklers. One thing that I've been told as I've made this presentation a couple of times in public is this is a very confrontational approach. I'm not going to deny that. Instead, I'm going to answer that question with another question. Where would anyone get the notion that any of our founding fathers that wrote the Declaration of Independence, fought in the Revolution War, and ratified the Constitution were in any form or fashion afraid of confrontation? The Constitution and its Bill of Rights is by its nature a rather confrontational document. Just read the Declaration of Independence. It's in by no means being unfirm in its approach to dealing with the problems of the day. There's also a very peaceful strategy to dealing with this as well. In a recent case, I noticed the Amish defeated the federal government regulation requiring a registration of their livestock. The Amish being Amish, they're not going to register your livestock even if you pass a law saying they have to. But the important thing is the judge noted that they packed the courthouse. One of my favorite people I like to listen to is David Gibbs. He tells a story of how over 14,000 Christians showed up to face the governor of Ohio when parents sending their children to a private Christian school were sued. The Ohio Attorney General dropped the case. In other words, when your brother is sued, show up, bring a Bible, pack the courthouse, and pray. You don't have to do anything other than that. Just simply the large crowd of people praying and holding their Bibles can sometimes sway a case. Final notes on this. We can't force anyone to pray or take a Bible. Please don't try. That's not what I'm advocating here. I'm just advocating for defending our own rights. Peer pressure is not an excuse for commission of a crime. Peer pressure is not force. Don't take this as a reason for violation of separation of church and state. Now, the reason why I bring this up, as we'll cover in just a moment, there's some cases where the Gideons have brought Bibles to school. A student took the Bible, and the parents complained, saying that, well, they were forced to because their friends did it. That's peer pressure. It doesn't work for anything else. If you get caught racing, peer pressure, racing in the streets with a car well over the speed limit, peer pressure is not going to get you off. If you get drunk in public and you tell the officer, well, my friends were drinking too, that's not going to go anywhere. Peer pressure is not force. I don't advocate pushing religion on anyone. I'm just fighting people who are pushing atheism on us. That's ultimately my point, my cause, and that's what this is all about.